Welcome to Chicago's Legal Latte, a series of podcasts brought to you by Lavelle Law Limited. Throughout this series, the attorneys from Lavelle Law will share their answers to questions about a variety of topics for individuals and small businesses.
Hey everyone, this is Jim Mitchell, welcoming you back to another edition of Chicago's Legal Latte as we come to you with our video version. For those of you who are able to download video, we still have our audio component going on Blog Talk Radio as well. And today we're going to kind of bring to a close a three-part discussion we've had with Ted McGinn of Lavelle Law, Bill Germanetti of Impact Business Coaching, and David Gronski of North Coast Capital Advisors as we talk about the closing. So far we've talked about the business transaction process from letter of intent to due diligence, and now we kind of get to the end of net strings. But first of all, Bill, Dave, and Ted, thank you for being here. Good to see you guys again. Looking forward to our conversation today.
Good to see you.
Thank you. Good to be here.
Yep, good to be here again, Jim.
So, Ted, I know you've been through many of these. We talk about the closing. You've had offers and a lot of research done, maybe months worth of work. It's time to actually sign the papers. Who's going to come to the closing? Who are the critical people to be involved?
Well, obviously the parties, the buyer, the seller, they typically are there, of course. Also their attorneys representing each party normally has an attorney. And then beyond there, it kind of comes down to the nature of the transaction. You could have a lender involved. There could be a cash deal. There could be a title company involved if you're dealing with a real estate component. So there's a number of other, sometimes there's brokers who want to get their commission. So it's a variety of parties that could be at the closing.
And as they show up, a lot of work has been done. Hopefully everything's in place. What do they bring with them? Are there materials? Are there documents? Or do they show up with a pen in hand and ready to go?
Yeah, well, the buyer, they need to bring their money. They're going to bring some payment of some sort to the closing. It could be cash. It could be a promissory note, some sort of payment that they're going to bring. And then, of course, a seller, they need to bring the deliverables, which is typically in an asset purchase, it would be a bill of sale. And then in a case of a stock deal, you're going to have the securities that are going to be transferred. So that's the fundamental important components that you're going to bring to the closing. Then, of course, beyond there, it's all in nature of the transaction.
Mm-hmm. Bill, you've been, doing these for 40 years, working with small, mid-sized businesses. Most recently, the last 20 or so, as a business consultant. As you walk into these events, they've probably evolved, and I know in recent years they've become more of a remote, virtual event. Is that what you're seeing now? Is that perhaps the trend we're going to see, is that we don't all have to be in the same room anymore?
Yeah, I see people who really want to press the flesh still, and seeing the other face. So even through the pandemic, I saw some resistance to the remote closings. A lot of times in this space, it's still a very personal transaction, and people want to really do a good transition. So I see the remote closing more for people who are traveling, or not everyone can make it, save some travel time, got a few extra people on the call. So it's more convenience with a remote rather than the pandemic related.
Got it.
I agree. Since 2018, all the closings we've been involved with have been remote. One was because of a snow day, but it is easier to do. And usually when you get to the closing table, it's really formality of let's sign the documents and move forward. Hopefully all the other issues have been resolved by that point in time.
But that's not always, let me jump in real quick. That's not always the case. Sometimes issues are not resolved, and that where you get the face-to-face closing, you got some additional haggling and negotiation coming on. So again, it's a function of the nature of the particular transaction.
And I think what I see at the last minute is working capital inventory type issues where the number hasn't been really nailed down. And those are always like the things that, okay, how are we going to get around this? So
yeah.
Yeah, Dave, I want to jump in there. You have a boutique M&A investment bank. You serve lower middle market companies, as you've mentioned. You've been doing this a long time. And Ted mentioned money. We've got to have the exchange at the closing. Talk us through what happens financially at this. Are there outstanding loans that need to be paid off? How does
Dave,
that
do
get
they bring
done?
a briefcase of cash? Is that how you do it?
By the way, I've had a client that actually was bringing 200,000 in cash that we couldn't do because of obvious reasons. But no, usually the cash at closings all decided upon beforehand if it's going to be wire or certified check. So at the closing table, it's really okay. Is the wire going through? Make the call. We'll get the confirmation. If it's a certified check, it's presented at the closing table.
And with that, are there current concerns? I read everywhere about cybersecurity issues, scams. When you start wiring money, unfortunately, it seems to be a little more tenuous than it used to be. How are we protecting against issues there?
Well, from my perspective, wire transfers are pretty secure because it is bank to bank, and they've got their network. If it goes outside the normal banking system, I'd say a big caution flag goes up as to how do you make sure that your money is secure.
Yeah, the big scam that happens is an email will be intercepted. Parties are exchanging wire information via email. And if somebody has some sort of malware downloaded on the computer, they could see that email back and forth, jump in and send another email, say, hey, we've updated our wire information. These are the new wire instructions. And of course, the email appears to be a legitimate email from one of the parties, but it's really a faulty email providing false wire information. And if you're not careful, you'll end up wiring money to the wrong account, some fraudster's account. So what we try to tell our clients then, you need to verify wire information over the phone. I mean, you can exchange the email, that's great, but there has to be some sort of verification over the phone.
In my prior career, I was a cash manager for multiple Fortune 500 companies. So I would handle the wire transfers, and you knew the banker knew you. You had all the authority granted to you by the management team. But if there was something that was out of whack, the bank will circle back and call like the treasurer or the CFO or somebody if something doesn't look right. So in the lower middle market, you don't have that type of security set up. So it's really make sure you're with your banker is at the closing with you.
Let's jump into the closing meeting itself. We're about halfway through our conversation today with Ted McGinn of Lavelle Law, Bill Germanetti of Impact Business Coaching, and David Gronski, president of North Coast Capital Advisors. We're talking about closings, and at the closing, who's running the meeting, and is there a closing statement or document that sort of serves as the agenda so everyone knows what's happening in what order?
Yeah, I mean, usually the seller's attorney is probably the one that, I guess, for lack of a better person, running the closing. But it could take place at a number of locations: a buyer's attorney's office, seller's attorney's office, sometimes at the actual location of the business. So it could be a number of different locations. But the closing statement you mentioned, Jim, that's kind of an important document, and that's something that parties will execute at the closing. The closing statement is going to track and follow the funds flow. Who's going to get paid what? Because a lot of times, you think the seller's going to get the money. Well, there may be a number of costs that also have to be satisfied out of those closing proceeds. Perhaps a payoff letter for a lender, a commission for a broker. There could be some, maybe a cost or survey, other fees that are associated with it. All should be paid at the closing. All that is summarized in the closing statement. And the other thing, as Dave mentioned earlier, working capital reconciliation issues or inventory issues, all that is kind of covered in the closing statement as well.
So, Dave or Bill, maybe you guys can help me out here, because as we look at the due diligence process has been taking place, but both companies are still running, even up to the point you walk into the meeting. They're conducting business, at that very point. But there's variables. So things like inventory that Ted mentioned, and maybe sales that are in progress. Who's tracking all that, and how does that factor in to make sure everything's reconciled?
Well, the company's running normal business. Okay, the accountants, the business is run as normal. The buyer's going to put his two cents into looking at verifying all the data. Usually, like inventory and working capital, you look at when you're closing on the calendar. Does the business have a different cycle? Is it like a big year-end deal, or is it consistent throughout the year? So you're looking for normality of what that will be at the time of your closing. You target a number, and then at the closing table, and usually it's probably 2 weeks to a month after the closing, you what we call true up the number to say, okay, here's the difference between what we targeted and what the actual amount is, and the true up will either be a credit to the buyer or a debit to the seller. So
good. And there's been a term I saw here, bulk sales holdback. I've not heard that before. Can someone kind of walk me through that?
Yeah, I could take a stab at that. I mean, in Illinois and in a number of other states, they have what is known as a bulk sales act. What that means is anytime you have an asset transaction where a buyer is transferring substantially all of their assets to a seller, the buyer is required to notify in Illinois, it's the Illinois Department of Revenue, and other states, whatever the state taxing authority would be, notify them of this pending bulk sales, and then the state will prepare some sort of an estimate of the sales tax liabilities or employment tax liabilities. They'll estimate what they think the seller is going to owe through the normal operation of the business, and they'll tell the parties, hold back this estimate from the closing until those final tax returns are prepared and filed by the seller. And basically, it's a way for the state to make sure they get paid their taxes that are due to them. Now, the key component there, if this is not followed, the buyer could be held liable for the seller's taxes. So this is important for the buyer to follow this as well.
Interesting. Couple of minutes left, and Bill, I want to turn to you because in our previous conversation about due diligence, we talked about how you communicate with employees. They may or may not know something's happening. They'll see activity around the office. Now the deal is getting done. What's the protocol for communicating with employees really on either side once a deal is finalized?
Well, there's different levels of transparency with the employees, depending on what kind of grouping they're in. There's most likely a lot of key employees that already know the buyer probably wants to make sure that they're going to come with the business. It's an important part of the business that continues to run. There may be some rank and file where it's we kind of set up shortly thereafter a company-wide meeting and really focus on the excitement of that. A lot of times I like having the seller part of that, so it can the nature of it, and sometimes what the seller can say positively can set it on the right tone, and why they chose this seller. We touched on along the way in this series about some of the motivations of the seller or the hesitation. So they certainly want to cash out, get a good price. But they do care about, in this space, they do care about their customers and they do care about their employees. And participating in that transition usually is something they want to do and can be really very, very effective.
It's a delicate balance.
We have a.
Sorry, go ahead, Dave.
I'm sorry. We have a deal right now. It's a good sized deal. There's 4 key employees. One is in the know of the transaction that's taking place, and we've sort of already negotiated her position. But the other 3 actually are holding up the final purchase price because the buyer wants to make sure he knows how he's going to compensate them, and how's that going to figure into the value of the company going forward. So, and we're sort of we're trying to push that to the last minute as much as possible. But the buyer's got a right to know. And, you know, again, it's very cautious because the employee, if they get wind of, hey, I've got a powerful position here, I'm going to renegotiate this, and they could screw up the whole transaction by what they might demand. So it's a very delicate balancing act.
Yeah, I would say that's one reason why, if you're thinking about selling or just a normal operating procedure, you may want to lock in your key employees in written agreements. So in a situation like that, you're able to transfer and assign those rights under those employment agreements. And that way you minimize any leverage these key employees may have to hold up a deal and renegotiate. And then the other thing I might add, sellers are often kind of worried about notifying employees, especially the rank and file employees, too early, because if a deal falls apart, the worry is, okay, now these employees, they're not sure, there's a lot of uncertainty, should they start looking for a job, and it can disrupt the normal operations of the business. So the seller tries to hold back as late as possible on the rank and file notification.
Well, we're going to wrap things up here. As always, I want to thank Ted McGinn, managing partner at Lavelle Law, and of course, many years of doing this podcast, both audio and video. You can reach Lavelle Law at 847-705-7555. Bill, why don't you just give a quick recap here of where we can reach you to find out more about your business?
Yeah, my cell is great. Texting is great these days. 847-544-6878. And we help companies that, you know, sometimes we first touch people when they're in trouble, but one of our fun parts are when they're transitioning either to family or a third-party sale, and trying to make sure that legacy lives on.
Thank you, Bill. That's Bill Germanetti of Impact Business Coaching. And David, quick recap from you.
Sure. Feel free to call me at 312-259-5876, North Coast Capital Advisors. You could go to our website. We're always available. I've got two other partners that are with me. So we jump on things pretty quickly.
Well, thank you all. It's been a great series. Certainly look forward to having the chance to talk again down the road. But thank you very much for being a part of the podcast.
Thank you.
Thanks all.